My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. First, the Ira Smith team hopes that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver, Inc. remains fully operational, and Brandon Smith, in addition to myself, are conducting all meetings by telephone or video meeting. So if you have any questions at all about this Brandon blog or anything else, shoot us a message, give us a phone call. We would love to hear from you. The title of today's Brandon blog is, What Does Receivership Mean for One Better Guarantor Bankruptcy Discharge? I hope you can watch until the end of the video, because I know you will get value from it. Today's Brandon blog arises from a bankruptcy discharge hearing that Brandon attended last April. It is a very, very unique and discrete issue that Brandon experienced and has today written about. It is very standard for companies in Canada who borrow money from banks or other lenders to use the company's assets as security for the loan. So the lender is a secured creditor of the company. It is also very normal in Canada for lenders to get the personal guarantee of the directors of the company or the shareholders of the company, the people in charge. So that way, if the lender has to execute and enforce its security against the company assets in a receivership, but comes up short, it then can look to the personal guarantors for payment. So Brandon first goes through in general, what does receivership mean? What does it mean in bankruptcy versus a receivership? What are employee rights in a bankruptcy, protection, bankruptcy, or receivership? And he refers you to earlier blogs that he wrote so you can get more detail on each of those topics. But he just gave an overview. Then Brandon gets into the main discrete issue that appeared. What happened was that a company couldn't pay its debts, and it went to a different trustee in bankruptcy, the president did, to have the company file an assignment in bankruptcy. The secured lender then appointed that trustee as the privately appointed receiver over the company's assets. The lender recognized that it was going to have a shortfall. Rather than just suing the president on his personal guarantee, the lender came to us and asked, would you be willing to be the licensed insolvency trustee in the bankruptcy of the president of the company? And we said yes. The lender made application to court. The president of the company actually consented to a bankruptcy order being made with Brandon as the trustee. The trustee administration went fine. We were prepared to recommend and give an automatic discharge to the bankrupt. The bankrupt's single largest consumer creditor was Canada Revenue Agency. They did not oppose his discharge. He owed various credit card companies money. None of them opposed the discharge. The lender was an unsecured creditor against the bankrupt president of the company because of the personal guarantee. And they filed a claim in the bankruptcy. as did the receiver of the company in receivership, because the receiver went through the books and records and felt that the bankrupt individual owed the company money. Now, they all filed proofs of claim. The only one who opposed the bankruptcy discharge was the receiver, standing in the shoes of the company. We came to the discharge hearing. The court allowed the discharge hearing to continue, but raised a very discrete, complex issue. Does the receiver have standing to oppose the discharge of a bankrupt individual? Now, we had doubts about the size of the company's claim. We felt it was well overstated, but we also felt they were owed some money, at least on the outstanding shareholder loan owed by the president to the company. So that gave them status, in our view. The master, sitting as registrar in bankruptcy court, after hearing all the evidence, asked us as trustee, the receiver, and the bankrupt to make submissions in writing as to whether or not the privately appointed receiver had standing to oppose the bankrupt's discharge. We did the analysis, and Brandon has written the entire analysis that we presented to the court below. Bottom line, Brandon's conclusion, which the court accepted, was if the security agreement that the privately appointed receiver is operating under allows the receiver to operate the business of the company, then based on prior case law, the receiver, when running the business, is an agent for the company. In enforcing on the security, the receiver is agent for the secured creditor. So the receiver has a dual role in that example. In this case, the security agreement gave the receiver the right to operate the business. Therefore, our view was that as agent of the company, but not as agent of the secured creditor, the receiver had the right to file a proof of claim. Once you have the right to file a proof of claim, you have the right to oppose a discharge. In the end, the master agreed with our submissions. The master did not place a lot of weight on the receiver's submissions at the discharge hearing, and the court ordered that the bankrupt person should get an absolute discharge. So I invite you to read the entire blog below. It's full of very good information. Again, the Ira Smith team hopes that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver Inc. is fully operational. Both Brandon Smith and myself are holding all meetings by telephone or video meeting. So give us a phone call, shoot us an email message about this Brandon blog or anything else at all. We would love to hear from you.